Hey, everybody. I'm back for another lecture on the Judicial Branch. This is going to be a relatively short one. It won't be too long, but this will be Judicial Branch lecture number 2, and then there'll be a third one coming next week or later this week, sorry. So just to review, I want to go over some of the things we talked about the 3 layers of federal courts. We have the Supreme Court, the appellate courts, and the district courts. So we went over those. We talked about jurisdiction. That is, who has the authority to hear a case first. And remember that the Supreme Court has both original jurisdiction and appellate jurisdiction. And remember, original jurisdiction means that they have the ability to hear a case first. The district courts, if you remember those, are the lower courts of the federal government, and they only have original jurisdiction because they actually try criminals or try people that have put on or are being tried for a crime of a federal crime. And then appellate courts only have appellate jurisdiction. And remember, appellate jurisdiction just means hearing a case for the second time. If you're hearing a case on appeal, it's already happened before, the decision's already been made, and they're just seeing if the case was actually the Constitution was followed in the case. I think it's also important to know how appellate courts and Supreme Courts are set up different than a district court. A district court, you're going to have a judge, maybe a jury. You're going to have a prosecuting attorney, a defending attorney, a defendant. They're going to call witnesses. They're going to introduce evidence. There'll be objections during that. So it is the kind of court that you see on TV when somebody's on trial for a crime or when there's a civil case when 2 people are suing each other. The appellate court and Supreme Court aren't like that at all. The appellate court and Supreme Court, there's no witnesses being introduced. There's no testimony being given. There's no guilty or innocent decision being rendered, except for maybe in a case of original jurisdiction Supreme Court. But it's just going to be judges listening to attorneys talk. And that's what an appellate court and a Supreme Court do. If you could actually go to the Supreme Court and you can actually watch them. It's first come, first serve. And all that happens is that somebody stands in front of a podium and the 9 justices are sitting up, at least at the Supreme Court. The appellate court, usually it's 3. But the justices are just sitting up high on the bench looking down at you. You're standing in front of the podium, and then a green light goes on. And that means it's your turn to talk. And when the red light goes on, your turn's over. And the judges are interrupting you, asking you questions about the legalities of your case. So it's different than a trial court than what you see on TV. There's no objections there's no evidence being introduced. There's no witnesses testifying against each other. All that's already happened at a previous case. The appellate courts and Supreme Courts are just there to hear the case, and they've already read all that case details. They're just there to listen to the arguments, the legal arguments put forth by the attorneys from each side to see if the Constitution is on whose side. And then that's what they're making a decision on. Okay. All right. So we talked about jurisdiction. We talked about the lower courts, and we talked about how judges actually get appointed to the federal courts. And it's important to understand how partisanship and political ideology and makeup of the Senate and all those things influence how somebody gets appointed to a federal court. Okay. So with that, today we're going to talk about a judicial philosophy today, a couple different judicial philosophies, one called judicial activism, and then the other one called judicial restraint. Okay. These arguments are going to sound a little familiar, sort of like a loose constructionist or a strict constructionist or an evolutionist versus an originalist. Okay. So let me share my screen with you here. Okay. So these are our 2 topics for today, judicial activism and judicial restraint. Okay. Now, judicial activism. Let's go ahead and define what judicial activism is. Judicial activism says that courts should take an active role in solving America's societal, social, or economic problems. Okay. That is, through their decisions, the courts can solve problems in the United States. And a judge that practices judicial activism is said to have the guardian ethic. And you see that right here, because they consider themselves to be the guardians of the people. Okay. And they say it's their idea through their interpretation of the Constitution to solve societal's problems. Okay, so that would be judicial activism. Let me give you some examples of judicial activism. For example, requiring states, prisons to modernize. That would be an example of judicial activism, right? So somebody sues a state prison for unfit conditions, and it makes it to the federal level, and the federal judges issue a decision that requires the states to modernize the prisons. It's kind of like passing legislation almost, okay? Forcing busing to achieve integration between races would be considered a judicially active decision. Striking down laws which judges say violate the Eighth Amendment's cruel and unusual punishment, say, for example, a death penalty law. So if there's a death penalty law which strikes down, which is stricken by the Supreme Court, some people would say that's judicial activism, because you're in essence passing a law outlawing the death penalty, okay? Criticisms of judicial activism is they say it's in essence judges legislating from the bench. It's judges making up laws through their interpretation of the Constitution, okay? And so that should sound familiar a little bit. That's sort of like a evolutionist approach to the Constitution, which we discussed all the way back in October. Sometimes maybe referred to as a loose constructionist approach to the Constitution, okay? So typically judicial activism is usually associated with somebody that has more of a liberal ideology, okay? And I'm going to give you the other side and why they would be critical of a judicial active judge. And then let's talk about why a judicially active judge will be critical of a judicially restrained judge, okay? A judicially restrained judge would also be referred to as an originalist. And they would say it's okay for courts to make decisions that deal with new phenomena that hasn't been around yet. For example, when it comes to email and privacy laws. Okay, email was not around when the Constitution was written, and privacy laws obviously could not apply. So now a judicially restrained judge would say, okay, we have to now interpret the Constitution because that's a new phenomenon that didn't exist before. So at that point, we're not being judicially active. We're just applying the Constitution's principles to a new phenomenon, okay? But a judicially restrained judge would say, if there is a societal or economic problem that needs to be addressed, that needs to be addressed through legislation or the amendment process. So a judicially restrained judge would say, for example, the death penalty. Is the death penalty a violation of the Eighth Amendment's cruel and unusual punishment clause? And a judicially restrained judge would say, no, it is not. Because, they would argue, the very definition of a felony when the Constitution was written was a crime punishable by death. And so a judicially restrained judge would say, it's not up to me to interpret the Eighth Amendment to make the death penalty unconstitutional. If we want to make the death penalty unconstitutional, a judicially restrained judge or an originalist would say, they would say pass an amendment to the Constitution. And that judicially restrained judge would say, I may be against the death penalty. I may not like the death penalty, but it's not up to me to just interpret the Eighth Amendment and say the death penalty is now unconstitutional. So a judicially restrained judge or an originalist believes in a strict literal interpretation of the Constitution, okay? So they say that we should follow the original intent of the founders, okay? A judicially active judge would say, well, as new phenomenon come around or new situations come around, like let's say, for example, is it okay if a state passes a law that says minors can be put to death, that a 13-year-old or a 12-year-old can be put to death? Is that a violation of cruel and unusual punishment? Okay. A judicially active judge would also say that the legislative process breaks down sometimes. For example, without Brown versus Board of Education, how much longer would segregation have ruled in the South and had segregated schools? Unless the Supreme Court ruled on Brown versus Board of Education, ordering schools in the South to desegregate, how long would people's rights have gone on to be violated by the state governments? And they would argue that states were violating the Equal Protection Clause of the 14th Amendment. People were not being treated equally under the law. And therefore, a judicially active judge would say, we are the guardian of the people's rights. Remember I talked about in the last lecture, where judges are to protect the minority from the tyranny of the majority. For example, in the South, the majority, that is all whites, were violating the minorities, that is all blacks, rights in the South. And it was the job of the judicial branch, they said, to step in and protect minority rights. We are the guardian of the people, okay? And so even though it doesn't specifically say in the Constitution that segregated schools are illegal, they would interpret that through the Equal Protection Clause of the 14th Amendment, that people were not being treated equally under the law and their civil rights were being violated. Therefore, we were going to solve that problem. Okay? And so both of these philosophies both have strong arguments, but they both have flaws to them. And I think it's important that at this point, if we were in class, I would have you turn to each other and explain the difference between a judicially active philosophy from a Supreme Court justice and a judicially restrained philosophy from a Supreme Court justice, also called an evolutionist approach or an originalist approach. I would have you give examples providing what a judicially active decision would be and examples of what a counter argument would be towards those, and the same thing for judicial restraint. Okay. I could see this being an FRQ for the argumentative essay. I could easily see this being one of the argumentative essays that is put forth because you are going to get an argumentative essay and some statement talking about whether judicial activism or judicial restraint is the preferred philosophy for America to follow. You would definitely want to put in there, and probably primary documents you would have to use would be the Constitution, Article 3, talking about powers of the federal courts. Federalist Paper number 78 would definitely come into this. Hopefully you've watched Federalist Paper number 78, the video that I put on there. And Fed 78 would say that judges were given lifetime appointments, so they could be the guardian of the people, right? They only have to be appointed and approved. So they do have the independence to protect the minority from the tyranny of the majority, right? Or you could argue the other way and say, like a originalist would say, if we don't clearly follow exactly what the Constitution says and the original intent of the founders, then why even have a Constitution, is what an originalist would say. We could just leave the Constitution open to anybody's interpretation, and anybody can interpret anything the way they want it to be. Why have a Constitution at that point, is what a originalist would say, okay? Especially with the Eighth Amendment case. Why does a judge all of a sudden get to just interpret the Eighth Amendment to make the death penalty unconstitutional now? When the Constitution was written, the death penalty was there. It existed, and people were put to death by crimes. If they wanted to make the death penalty unconstitutional, they should have put it in the Constitution. And if we want to make the death penalty unconstitutional, we should go through the amendment process, have Congress propose 2/3 amendments, and then ratified by the state legislatures, okay? So this is something I would have gone over right here if we were going to have some multiple choice, going over some examples of different presidents and who they appointed to the Supreme Court. But you know, I don't think that's necessary right now. So for the sake of time. Okay, moving on. What we have here is the blue showing you how many cases get appealed on an annual basis to the Supreme Court and how many cases the Supreme Court actually takes, okay? And so the trend that we see here is that in the year 1960, we had just under 2,000 cases that were appealed to the Supreme Court, and they accepted around 150. And as of, say, 5 years ago, we had almost 10,000 cases get appealed to the Supreme Court, and they accept less than 100. And on a regular basis now, the Supreme Court only accepts about 80 cases a year. And normally we would have a class discussion of why is this? Why do we see this trend of so many more cases being appealed to the Supreme Court? And why does the Supreme Court actually accept almost, say half of the number of cases they used to just 50 years ago? We would have a discussion on that. And we would say that there's so many new phenomenon today. Society is way more complex than it was just 60 years ago. Who could have thought that there would have been a court case before the Supreme Court about cell phone privacy laws with your location being pinged off of cell phone towers, and whether or not law enforcement officials needed to get a search warrant to be in compliance with the Fourth Amendment, right? I mean, these are just new phenomena that didn't exist before, just even a few short years ago. So society is just way more complex than it used to be. And because of that, because our cases have become so more complex, I think judges are accepting less and less and less, Okay. So let's go ahead and talk about the Supreme Court. And this is showing you basically the bar graph version of the exact same one, the number of cases that get appealed and then the number of cases they actually decide upon. A lot of times the Supreme Court will issue what's called stare decisis. They just won't accept a case. And stare decisis means let the lower decision stand. So many times the Supreme Court will get a case appealed to it, and they'll either just reject it or they'll take it and issue a stare decisis, which means the lower decision is going to stand, and they're not even going to have any kind of court case on it. So also keep in mind that the Supreme Court will sometimes find a way to not take a case if it's a political hot potato. The Supreme Court will find ways or just won't accept cases if they think maybe society's not ready to deal with that yet. For example, okay, same-sex marriage was legalized, I believe, in 2015. And the legal justification was that same-sex couples were being denied equal protection under the law, so therefore is a violation of the 14th Amendment's Equal Protection Clause. And I would ask this question: why all of a sudden in 2015 did the Supreme Court decide that same-sex couples were being denied equal protection under the law? If that was true in 2015, wasn't that also true in 2005? And wasn't that also true in 2000, 1990, and 1980? Why did the Supreme Court wait until 2015 to take on the case of same-sex marriage? And the answer is if they had done it back here in 1970, the vast majority of states and the vast majority of people would have probably just ignored the ruling. And states would have just not performed same-sex marriages. And the public would have not been as accepting as they were, in 2015. And so many times the Supreme Court will find a way to either just not accept a politically hot case, or they'll find a way to find some sort of loophole where they can get out of making a decision on it. Because if the Supreme Court issues decisions, or what we call opinions, on a case, and nobody follows that opinion, then they in essence have weakened their own power. If the Supreme Court hands down decisions and states ignore the ruling, then what has the Supreme Court done to itself but just rendered itself less powerful because nobody's abiding by their decisions? Okay. Can you imagine if in 1954, when they passed Brown versus Board of Education, and remember the Southern states resisted, they just kind of didn't do anything, almost like giving a giant middle finger to the Supreme Court, if you will. And what did it take? It took the 101st Airborne and Eisenhower saying, we're going to integrate schools. The president had to use military to force integration in some of the Southern schools, right? So can you imagine if the Supreme Court issued rulings and the president just ignored the ruling too, or didn't enforce the ruling of the Supreme Court? Okay, that in essence would be the Supreme Court weakening their own power. So many times the Supreme Court will kind of, like I say, hot potato. They kind of just don't want to touch a case that they know is a political hot potato because they're afraid maybe the people will just ignore it or the states will ignore it as well. Okay. All right. Okay. So let's do a little background here on the Supreme Court. And then I think it's going to be a short number, and then we'll stop there. Yeah. Okay. So here we go. The Supreme Court, there's 8 associate justices and 1 chief justice. Keep in mind, Article 3 really didn't talk about the lower courts much. That happened with the Judiciary Act of 1789, I believe. So Article 3 is the shortest article of the Constitution. The founders really dealt with Article 1 because the legislative branch was kind of a new idea. Article 2 because having the single executive was sort of a new idea too. Article 3, we kind of just took our law ideas from England almost. And so that's why it's the shortest article. So 8 associate justices, 1 chief justice, all appointed by the president, all approved by the Senate, and all serve as long as they're on good behavior. The chief justice is not the longest serving justice. The chief justice is when the chief justice resigns, or if the chief justice passes away, the president gets to appoint a new chief justice. Our current chief justice, let me come back up here to this picture, is this man right here, John Roberts, who was appointed by President Bush. Okay. So what sort of authority does the chief justice have? Let me get back down to here. And the answer is not much. The chief justice, when a case is over, all the 9 justices go and sit in a room and they discuss the case with each other. We were actually going to do a Supreme Court simulation in class. I'm sorry we can't, but it's pretty fun. We were going to recreate the Tinker v. Des Moines case, and it was a fun time every year, but obviously we can't do it. So after a case has been argued by both sides, all the justices will go back into a room and they all discuss what they think about the legal opinion should be. And one of the things that the Chief Justice gets to do is talk first. Yeah, it's a big power. Yeah. But the other thing the Chief Justice gets to do is if they are on the winning side, the Chief Justice gets to decide who writes the legal opinion. And that's kind of a big deal. But I'll come more to that later on, okay? I'll talk about why it's important of who gets to assign the writing of legal opinions, all right? So remember, key powers of the Supreme Court is they have the power of judicial review, which comes from what court case? Who can remember in your head? Think what court case? That's right, Marbury versus Madison, okay? So, and like I think I've given you these data before, but I'm going to give it to you again. We've had over 1,200 state laws have been overturned as unconstitutional because of Marbury versus Madison. We've had somewhere around 175 to 200 laws, federal laws, be overturned by the Supreme Court as being unconstitutional. We've had presidential actions like executive orders and executive agreements and executive privilege be overturned as unconstitutional. For example, remember Nixon tried to use executive privilege and the Supreme Court said, no, you're not going to use that right now. Okay, so that's a big power that they have, okay? And remember, Congress passes these broadly worded laws that have a lot of gray area in them, and the Supreme Court kind of gets to interpret what those laws mean. The Supreme Court, in essence, gets to write law whenever they make a decision. And I think that's a key term to know here, is when the Supreme Court issues an opinion, they are in essence writing the Constitution. Because when they issue a decision, also called an opinion, they're saying, here's what the Constitution says. And they're setting that precedent that from here on out, everybody's going to follow what they say the law is, okay? And then they can overrule their previous decisions. Like I said, it's been over 200 times that the Supreme Court has reversed itself, okay? Over 200 times. I think I gave you the example in the last lecture of Gidding versus Wainwright. Gidding versus Wainwright had originally been Batts versus Brady. Batts versus Brady, they said, no, the states do not have to give you the right to counsel through the Sixth Amendment. That's only at the federal level, only in special exceptions, special cases. And then Gidding versus Wainwright, the Supreme Court overturned itself. Okay, remember Brown versus Board of Education was overturning a previous decision of Plessy versus Ferguson. So the Supreme Court will issue an opinion and say, here's what the Constitution means, and then later overturn themselves. And we'll get to how that's important with opinions, okay? So here is the basic way that a case can reach the Supreme Court. You can come up through the state courts. You can have a trial at the state level, the state court of appeals, the state Supreme Court, and then you can appeal to the U.S. Supreme Court. You can have a trial at the district court level. You can not like that opinion or ruling, appeal to the U.S. appellate court, and then go to the Supreme Court there. Okay, but keep in mind, thousands and thousands of cases get appealed to the Supreme Court every single year, roughly 10,000, and very, very few get accepted. What kind of case would most likely be accepted? If you have a constitutional issue where there are many states that are interpreting the Constitution differently. So that kind of issue is going to be sort of a catch for the Supreme Court. We're like, okay, we have this constitutional issue and states are interpreting the Constitution differently. We can't have that going on, okay? The Supreme Court gets to decide which cases it takes by what's called the Rule of Four. The Rule of Four means if 4 of the 9 Supreme Court justices all agree they should put the case on its docket. The docket's a fancy way of saying their calendar for the year. Okay, the docket is which cases they're going to hear for the year. So if 4 justices say that this is a case that needs to be heard, it then goes on the docket. That's called the Rule of Four. Now, what happens is that you get these Supreme Court justices that have certain causes that they want to have solved while they're on the Supreme Court. So they have clerks that work for them. And there are literally, like I said, thousands of cases which come through the Supreme Court and get appealed every year. And these judges on the Supreme Court will tell their clerks, look for this kind of case. If you happen to see a case that is like X, please bring it to me and I'll let you know if this is a case that I am interested in. And so a lot of these causes a lot of these judges have specific causes that they want to take up. For example, Gideon versus Wainwright, I'm going to come back to that one again. Justice Hugo Black was on the original Supreme Court when Betts versus Brady was challenged, and he disagreed with the court's ruling. He said we should have to give an attorney to all people that are tried at the state level. And so for 20 years, he kind of seethed, and he was telling his clerks, look for a case like that again. Look for a case like where somebody was denied the right to an attorney at the state level and was convicted in a court of law and is now serving in prison. I want that kind of case. And so a lot of times the clerks are looking for specific kind of cases, okay? So why would a case be denied? Well, we already talked about that the case may be too much of a political hot potato, and so the Supreme Court would kind of say, no. If they can't get 4 of the 9 justices to hear it, obviously it goes there. Maybe there isn't a substantial federal issue that they're appealing on, right? Maybe it's a state issue, and the Supreme Court would say, well, that's a state issue. We don't really have jurisdiction over that. We have jurisdiction over constitutional issues, not a state law, unless that state law conflicts with the federal law, with the Constitution, of course, right? If the people that brought the case lack standing, okay, meaning that they have not shown that they have been damaged. Let me give you an example. President Obama was famous for passing the Affordable Care Act, also called Obamacare, and it didn't reach the Supreme Court until 2014. And yet I believe the Affordable Care Act was passed in 2009 or early 2010. So why did it take 4 years for people who totally disagreed with the Affordable Care Act? They thought it was unconstitutional. Why did it take 4 years? Well, because the tax that people had to pay under the Affordable Care Act didn't kick in until 2014. So nobody had standing to sue on an individual basis, the federal government, for the Affordable Care Act. Once somebody paid the tax for not having insurance, which is the Affordable Care Act said if you didn't have insurance, there was a fine you were going to pay, and you were going to have to pay that through your taxes. Well, once somebody paid the fine, they then said, I have standing because I've been damaged by this unconstitutional law. Then lawyers could pick up on that case, states could pick up on that case, and then sue the federal government at the Supreme Court level. But so you can't just create a case because you disagree with the law. Somebody has to have standing. A judge can't just create a case because they want to fix the societal problem, even if they're an activist judge. They are passive power. They have to wait for cases to come to them, okay? And then another reason for denial is the Supreme Court will say stare decisis. The lower decision stands, whatever the lower court said, that's the way we're going to go, okay? What else? So how you get your case to the Supreme Court is you file what's called a writ of cert, okay? A writ of cert. And these are petitions right here. These are petitions to have the Supreme Court hear your case, okay? All right, so I think that's pretty good for today. I have one more lecture I'm going to need to do talking about judicial opinions and how do we check the Supreme Court. But again, today, the key things to take a look at here is how does a case actually reach the Supreme Court, and what are some powers the Supreme Court has, the 8 associate justices, how many cases actually reach there, what are the odds, and then you really know judicial activism and judicial restraint, okay? As always, if you have any questions, please email me. I have office hours on Thursday from 9 to 10 in the morning, but you can email me whenever you want. I'm going to answer your questions, okay? Don't worry if it's on a Monday or a Saturday or a Wednesday or a Sunday. I don't care. Go ahead and email me and I'll get back to you, okay? All right, everybody. Hope everybody's doing well, and hopefully I'll be able to talk to you. Take care.